SJC-12691, Douglas M. Rawan, and another v. Continental Casualty Company.
Mr. Vine, good morning.
Good morning, Your Honor.
We all set? Thank you. Your Honor, Daniel Line on behalf of the plaintiff appellants Douglas and Kristen Rawan. I would ask to reserve 2 minutes of my time for rebuttal.
Oh, we don't do that. But if we need to call you back, any member of this court can invite you to do so.
Thank you.
It has not been productive, but go ahead.
This appeal presents a very stark question of law. Can Massachusetts insurers contract out of their statutory duties under 176D, Section 39F, by ceding to their insureds the exclusive power to settle claims? This happened in this particular case where CNA actively and vigorously markets consent to settle policies that have no hammer clause in them, thus ceding to the insured the exclusive power to settle all claims.
If they did have hammer clauses, would they be okay? If they did have hammer clauses with the
If they did have hammer clauses, I would suspect it would be more palatable in the sense that it puts some kind of a governor on an insured's
would they be okay
behavior,
under
but
your
it would
theory?
not be okay under the statute. The statute says what it says. It does not carve out a hammer clause exception.
Does it carve out any kind of exception, or is it all consent to settle?
It is very specific that under 39F, an insurer is obligated to effectuate a fair, speedy, and prompt settlement of claims once liability is reasonably established. I think it's important here to look to CNA's argument as it breaks down. CNA's argument is based at its core on the notion that it has an unfettered right to contract as it sees fit with its insureds, and that once CNA passes that power to settle claims to its insureds, it no longer has any statutory duties under 39F. And also, CNA's argument is, because 176D is directed to insurers and not insureds, its insureds have no obligations under 39F to promptly, fairly, and equitably settle their claims. The only loser in this equation, of course, is the single party that had nothing to do with the contract, and that is the claimant. The claimant loses its statutory protections entirely under CNA's analysis of 176D.
The duty to the claimant as opposed to the insured, can you articulate where that comes from? Because they clearly have a duty to the insured. I'm trying to, and I understand there was a statutory amendment that imposes a duty, some type of duty towards the claimant, at least when the insurer controls the defense. But I'm trying to understand that duty because it puts this insurance company in this conflicting position where it owes a duty to its insured and, in your view, to the claimant. I just want to understand that duty better and what its origin is.
I understand. First of all, let me make a simple observation, which is that the conflict is entirely of the insurer's making.
Well, not completely. Right? I mean, the insurer is not bound. This isn't one of those statutorily mandated insurance provisions. This is, a world in which you contract for insurance. So
you contract for insurance subject to the strictures of 176D. And specific in 176D is the unfair claim settlement practices provisions under Section 3.9. So you may do as you wish as an insurer, but you cannot do harm to Chapter 176D and the strictures in 176D. This issue was addressed.
Again, most of it is directed at the duty to the insured, right?
No, I disagree with that.
Yeah, but then can you go back to my question and tell me how we interpret the duty to the claimant and where it comes from? So it comes from the statutory language itself?
So let me refer the court back to the Clegg v. Butler case, because that looked to the issue of whether or not 176.3.9, and in particular 3.9F, was somehow directed only to the insured because there's no privity of contract between insurer and claimant. And the court said the statutes at issue were enacted to encourage the settlement of insurance claims and discourage insurers from forcing claimants into unnecessary litigation to obtain relief. And footnote 5 is telling, because it says, "We note, however, that subsection G, by its text, is explicitly restricted to insureds. There is no such limiting language in subsection F, a clause which we read to apply to any party whose legal interests might be adversely affected by an insurer's failure to effectuate settlement where liability is reasonably clear." So the court has wrestled with this issue and has made the necessary determination. But the troubling issue here, and what we say is the per se violation, is the notion that is advanced by CNA, which is they have the right to contract out of their obligations under 176D.3.9, and in particular 3.9F. And were the court to adopt this supremacy of contract argument, there's nothing to assume that an insurer could not expand its interpretation and the language of its contract, not simply to apply to its obligations under 3.9F, but its obligations, for example, under 3.9D, to make a prompt investigation based on all reasonably available evidence, and to allow the insured to control that, or alternatively, to control the disclosure of coverage issues under A. It is the power of contract versus statute that is at issue here. And as framed by CNA, this is an instance in which CNA is asking the court to find that the statute is servient to the contract. And the case law here is exactly the opposite. Again and again, the court has held that contracts are servient to statutes, which makes entire sense, especially when those statutes involve matters involving the public interest, safety, health, or welfare. And that is exactly what this statute covers.
Can I ask you, or you submitted some stuff regarding legislative history, I think somewhat recently.
I did.
What's the point of it?
The point of it is there is a theme flowing through CNA's papers that says, we tried. We tried to inform, we tried to cajole, we tried to make Mr. Lala understand his exposure and to increase his offer from X to Y. And that somehow that excuses the insurer. And in fact, the legislative history, which wasn't available at the time because we hadn't been able to find it at that point in time, but the Superior Court opinion adopted that notion, that there is a good faith safe harbor for insurers if they try hard enough to inform their clients that that is all their obligation is under the statute. So the point of the legislative history is to look to whether or not there is in fact a good faith safe harbor. So the original bill that was read in the first reading contained two very distinct carve-outs under the statute. First, that a party seeking relief under 3.9 would have to demonstrate such frequency of acts to connote a general business practice. And that language was struck in the second reading. But particularly relevant here is the language in 3.9F as originally drafted. In 3.9F as originally drafted, it was failing to attempt in good faith to effectuate a prompt, fair, and equitable settlement. That language was expressly rejected by the legislature between the second and third reading, leaving instead the directory language that currently exists, failing to effectuate a prompt, fair, and equitable settlement. I raise this issue because it addresses very directly the argument that the insurer can discharge its duty simply by attempting to inform its insured of the risks of moving forward. The problem here is that the contract provided to Mr. Lala the power to be the sole arbiter. In this particular instance, that gentleman was a clearly incompetent engineer who refused to acknowledge his liability, and there is nothing in the at least in the statute as interpreted by CNA, that gives the claimants any relief. Yet that is entirely antithetical to the language of the statute itself.
Do we know from the materials that you've provided or otherwise that the legislative history of this indicates that the legislature was very concerned about providing protections to claimants?
Yes, it's clearly in the legislative history. In the original bill that was read in, it's the prologue to Governor Sargent's tendering of the bill.
So this was not a bill that was intended to just deal with the insured versus insurer relationship?
Absolutely not. And indeed, the language in Section 3.9 includes references to both insureds and to claimants. So it was clear that the intention was to benefit both, and the Clegg case confirms the SJC's prior decision that says claimants are clearly the intended beneficiary of these protections.
But not the only intended beneficiary.
No, but under circumstances where a claimant raises a claim, then they are the beneficiary of that protection.
You know, I couldn't tell from the factual recitations whether that it was obvious to your client whether or not the insurer was really involved and was leading the negotiation.
Well, I'm not sure if we had perfect knowledge of that. I'm not sure that it matters whether the insurer was directing it or not. The issue that's being presented here is a rather stark one, and that is, does contract trump statute? Now, there's a wash of fragrant oil, to use Justice Lowry's reference, and that is the notion that there are professionals and there are other professionals. And so there is a army of amici that have filed briefs, mostly for attorneys, all saying that attorneys and doctors are somehow very, very different, and therefore they have to have the ability to protect their reputation, and the only way to protect their reputation is, of course, to control absolutely the settlement process. There is nothing in the statute that provides for a two-tier protection system. And I would argue that the reputational interests of plumbers or electricians or common victualers or commercial landlords who have spent a lifetime building what they consider to be safe and affordable housing all have reputational interests. If the argument is that somehow this is different and therefore this contract does trump the statute, then that's an issue that needs to be directed to the legislature.
So what is your rule? Is your rule that these provisions are okay? Because we can't write an insurance provision to say that you've got to include a hammer clause in every insurance contract, right? So is
No.
Are you saying that these type of consents to settle provisions are okay so long as they add the word so long as such consent is not reasonably withheld, or how?
No.
Tell us
No.
what you're saying, because you're asking us to rewrite the insurance policies
I
somehow.
am, and I'm saying very, very specifically that consent to settle clauses in insurance policies are void as a matter of law when viewed in this context.
So
you cannot have them.
So totally, the person who bought the insurance policy has absolutely no say over whether you settle or not? Is that what you're saying?
The insurance company is free to
Hold on a second. No, I just want to understand
to
what
work with them.
Well, look, again,
let
let
me-
me just pose a question, then you can answer it. So I'm just trying to understand it, because right now you say they have the unlimited right to withhold settlement. Are you saying they have no rights whatsoever?
Here's the rule that I would say is the appropriate rule. First, that the duty cannot be delegated. The duty under 3.9F cannot be delegated to an insured. The insurer maintains that obligation at all times. An insurer has an obligation, once liability is reasonably clear, to make a reasonable offer of settlement, up to and including a tender. A claimant is free to accept it or reject it.
Okay,
But the-
and I get that part, but we've got, this is a three-party dance. There's your claimant, the insured, and the insurance company. What is, the insurance company, in your view, has a duty to the claimant, I understand that. But what is, when the insured is objecting, what rights does the insured have, and how does the insurance company balance those two rights? Because you're asking us to do something quite complicated that's putting the insurance company in this dual loyalty position. I just want to understand what they have to do, or do they have no loyalty whatsoever to the person who bought the contract?
The person who bought the contract is subject to the statute just as much as the insurance company is. The insurer went out and actively marketed a consent to settle no hammer clause policy. Whether that is enforceable is a question that must be addressed by looking to both the contract and the statute. The fact that the insurer has created this conflict by contract is not the problem of the claimant. And it is a function of the literal language of the statute. And unless and until the legislature changes that language, which it is free to do at any time, the court's obligation—
What language in the statute precludes a duty to the insured himself or herself? I want to understand that, because we have to write a rule if you win that's going to give some guidance to the insurance industry, and I don't know what that rule is right now.
So the rule is that consent to settle clauses are unenforceable as a matter of law. They are a per se violation of 176D39F to the extent that an insurer claims that the consent to settle clause ties its hands and strips it of the ability to undertake its obligations under 39F.
So the entire provision is void against public policy?
Absolutely.
Can I ask you?
And I'm sorry, just a follow-up.
Sorry.
Yeah, so that would alleviate the breach of contract claims that are going to come?
Yes, it would.
Can I ask a question here? Of
course.
I thought that what you were asking for was simply the same kind of relationship with the insured that the insurer has in such things as homeowners insurance policies or auto insurance policies, where, there is a dialogue presumably between the insured and the insurer regarding settlement, but the insurer ultimately has to make the decision.
Yeah, and the standard clause is an
Standard.
expedient settlement clause.
Is that what you're looking for?
I am.
Okay.
I think that unless the legislature changes the law, the rule has to be that contracts are subservient to the obligations of the statute, and that means that the expedient settlement clause applies. The notion here, just to be clear, is that for members of the trade or other professionals, and there are 580,000 individuals and businesses that are licensed under 134 different licensing authorities in the Commonwealth of Massachusetts involving 64 different trades, that none of them have the right to settle, and that the expedient settlement clause applies to them, and nobody seems to have a problem with that. That has been the rule in the industry for decades. The only thing that is different here is that the insurance company says that there is a select group of professionals, and for that select group of professionals, they are going to give them absolute authority over the settlement process. If that is the case, then the insurers need to go to the legislature and ask for that safe harbor.
No, why? Why do they have to do that? I mean, the other insurance policies also regulated by the state?
They are.
Okay.
But the issue here is,
These are otherwise not?
no, these are regulated by the state.
Okay.
The state regulates.
But are the expedient, and again, I'm not as up to speed as Justice Link on the expedient settlement clauses, are those ones that the legislature has dictated must be in policies, or are those freely negotiated ones?
Those are, I'll say freely negotiated. It's what's offered by the insurance companies.
So they're not the provisions that the legislature requires to be included in certain insurance contracts, because there's a whole bundle of those provisions, and if the legislature dictates the provision, you got to comply with it, but if the legislature doesn't.
It is how the market has shaked out, well, put it colloquially. But the issue here, I think, is that there is a statute that does not include a two-tier system. All insurers and all insureds and all claimants are subject to 176.39. That is the unfair claim settlement practices provisions of 176D.
I'm going to ask the same question, I think, a different way. If the insurance company can't contract out of 39F, where's the insured's role here?
The insured's role is no different than the insured's role with every other trade or profession. There is an expedient settlement clause, and to the extent that somehow that is unpalatable to the legal or medical community, the only avenue they have is to apply to the legislature. The legislature is free to change this if it so chooses. But what the insurance company is not free to do is to provide provisions in a contract which effectively take out whole sections of 3.9. The way that the insurance companies interpret this language is that once they enter into a no settlement clause, they have no further statutory obligations under 3.9F. Under 3.9F. And therefore, at that point in time, the claimants are left without that fundamental protection, which is expressly included in the statute.
Can I ask you a simple a question, and forgive my naivete, but you struck a chord when you started talking about plumbers with me, at least. An engineer, an accountant, a lawyer contracts for this protection, reputational protection, correct?
Presumptively.
They're sold
Yeah.
this. Does the electrician or the plumber buy this insurance policy as well with this provision?
I don't believe that it's offered to plumbers and electricians.
Okay, so that's a distinction, right?
It is a distinction, but the issue of whether or not...
And I know your argument is we shouldn't allow this private contract to overrule, by virtue of public policy, this protective statute. I get that. But when you draw these distinctions between tradesmen, tradespeople, and professionals, it's kind of a false distinction because they're not involved in these contracts.
Well, but they are, the insurance company can be free to offer those contracts to tradesmen as well. The fundamental underlying principle is that the insurance company gets to contract as it sees fit, and if that contract does harm to the statutory obligation, remove statutory obligations from them, then yes, that is a clear violation of public policy.
What year was Section 3.9 passed?
1972.
And in 1972, were there professional liability policies which had these provisions?
I don't know the answer to that.
So we don't know whether or not the legislature, your view is that when the legislature enacted Section 3.9F, they intended that there be no such provisions in professional liability policies which would give the professionals the opportunity to have this option.
There is nothing in the legislative history that discusses consent to settle clauses. What the legislature did was to create a statutory set of obligations which are absolute. And they specifically, I want to go back to the legislative history here, they specifically considered whether an insurer could satisfy that statutory obligation under 3.9F by attempting in good faith to settle. They rejected that. Massachusetts has one of the most protective unfair settlement practices statutes in the nation. Most states have a good faith exception. California, for example. Rhode Island has that exception. Many of the states have an exception requiring that a claimant demonstrate a pattern and practice before they can sue under Section 3.9 or the analog to 3.9.
And what do you say is the implication, if any, of the Lazarus case, which says that when an insurer is faced with making a reasonable settlement offer, but the other side is not prepared to release the insured, the the insurer is barred from insisting upon that settlement.
I don't intend to do any damage to that finding. I don't think there's anything wrong with that.
But the basic theme is that when there's a tension between obligation to the claimant and obligation to the insured prevents the obligation to the claimant to kick in.
I think fairly, the Lazarus case was looking at the tension not between the insurer and the claimant and the insurer and the insured. The tension was the tension between the insurer and the insured, and the concern was that the insurer shouldn't be able to tender the policy and walk away from the client without a release. There's nothing wrong, and in fact, I think the Lazarus case clearly was decided correctly. I'm not suggesting that that be changed in any way, size, shape, or form. The question is, does the insurer continue to have an obligation under 39F to make a reasonable offer of settlement once liability has been reasonably established? That offer can be up to and including a tender. That offer can be conditioned upon obtaining a release from the claimant. I'm not suggesting otherwise. What I am suggesting and what I am advocating here is that when an insurer tries to walk away from that obligation by pointing to a consent to settle clause, that is a per se violation, both on public policy grounds and because it does express damage and ignores express provisions of the statute.
You indicated before that if the insurance industry wanted to be able to have these consent to settle provisions, it needed to get legislative change. What change is it to 176 or to the otherwise applicable regulations regarding certain kinds of insurance policies?
It's 176. So that presumptively the various amici, excuse me, and the insurance industry would go up and they would lobby for a change. They could lobby for a change, which is a series of safe harbors. There is a safe harbor for certain defined professionals.
So let me ask you in a different line. If the insured decides it does not want to settle, he does not want to settle, and later there's a finding somehow through litigation that the insurance company violated 176D by not making a prompt settlement, and the insurance company's defending with its, look, hey, I've got my contract here with my insured. Isn't there some opportunity for the insurance carrier to be made whole by turning the claim back to the insured and saying, you should have settled, even though you have an override?
Well, that, of course, is the hammer policy, is the hammer
Okay.
clause.
And you don't...
And CNA aggressively markets these professional policies with no hammer clause.
Okay.
It's a feature of their policy marketing materials. The problem, of course, is that there is absolutely no governor on an irrational insured, and under CNA's vision of the universe, the claimant has no recourse under these circumstances. Mr. Lala, however incompetent, Mr. Lala, and he was sufficiently incompetent that his license was revoked by the Commonwealth of Massachusetts for the work he did on my client's home, that there is
Is
absolutely...
that in the record, by the way?
It is. It's at the end of the
That's fine,
statement of
as long
facts.
as it's there.
No, there's no, I gather, there's no discussion in the judge's opinion as to whether or not $100,000 would be sufficient. I gather implicit in that it arguably would not be.
Yes. I should point out that the second half of the appeal deals with the actual claim settlement issues. The court below did not address any of those issues, the misrepresentation with respect to the actual settlement, policy coverage, which was misrepresented by 100%, at the same time that the insurer was refusing to produce prior policy declaration pages that would have showed that the increased coverage.
Right, but those we need to address, I believe.
Those you need to address. I think the easiest way to address them is simply to say these were inherent questions of fact and were not subject to resolution under the summary judgment standard.
But the question that I was asking is, if you prevail with regard to the view that public policy bars this clause, do we have any finding by the judge that the $100,000 offer was was inadequate under section 39F?
No, it has to go back.
It would have to go back to the
Yes.
trial court on that issue.
It does.
You know, it occurs to me that I don't understand the difference between when liability is reasonably clear, is it that there's here you could say, well, liability because the guy was just incompetent. That was reasonably clear.
He was,
What was reasonably clear about the damages, though?
well,
That has to
that
be
raises
reasonably-
the second half of the factual dispute. This insurer received the Hager report in August of 2000.
Yeah, but
and-
I'm talking about, how do you know whether or not it is reasonably likely that there'll be a certain amount of damages?
So this is the independent violation of 39D, which is the duty to investigate, looking to all available information. The insurer took no action to determine what the potential cost of remediation was for almost a year after the Hager report. And throughout the period of time that it was attempting to drive, I won't say drive, but to move my clients into a speedy mediation. If they had sufficient information to settle the case in a mediation, then I don't think they could say I didn't have sufficient information to make a settlement tender under 176D. I think that's grossly unfair. I will also say that when they finally got around to hiring an expert, which was only just before the final pretrial conference, that expert was, their review of the circumstances was unfairly and inappropriately limited, and the expert was instructed not to pay any attention to Mr. Hager's findings with respect to other and additional areas of the house that failed to meet basic building code structural standards. That was an instruction to that
Okay,
expert.
but the question is whether it is, whether liability is reasonably clear when you know the amount of damages or when you just know that the person was incompetent.
No, liability reasonably clear encompasses both liability and damages under
All right,
under the
okay,
cases.
okay,
It's clear with that. However, if an insurer is saying, but let's mediate and get this done, and let's settle this case, then an insurer is saying both to the claimant and to himself, presumptively, that he has sufficient information, not just with respect to liability, but with respect to damages. And that's exactly what happened in this case. So I don't think it's fair for the insurer under these circumstances to say, I have sufficient information to settle this case, but I don't have information to make a settlement offer.
All right, thank you.
Thank you very much.
Ms. Roman?
Good morning. Before I address what my colleague has described as a stark question of law, and certainly the one about which the court has many questions, it's important to focus on what is before the court in this particular case. Because regardless of the decision of this court on whether or not these clauses are valid or they're prohibited, the decision of the Superior Court here should be affirmed, because it's well established in Massachusetts that a carrier that takes a plausible, reasoned legal position that may ultimately turn out to be mistaken or unsuccessful is not liable under 93A 176D. And I have heard nothing here today nor read anything in the brief that would support the notion that it was so obviously clear that these provisions were unacceptable in policies or were outlawed by the language of 176D or any public policy, or that the carrier was free to disregard its clear contractual obligations to its insured.
So that's an interesting, you don't really make that argument in the brief so much, right? That the consent, whether, even if we conclude that the consent to settle clause was in violation of 176D, it wasn't clear. It's like a clear, all I can think of is the 1983 case is clearly established law. So you're saying that it wasn't clearly established law that consent to settle provisions are illegal. That's a kind of I take it that's your fallback position, but that's a different one than we've heard from before.
And, well, actually, it is a section in our brief.
Okay.
Just want to be sure about that.
Okay.
And it actually follows the argument about consent, because you're right, it is a fallback for this case. Because it is also something that quote was from the court's decision, the Superior Court's decision, quoting a decision of this court, Guidi. So basically, that's pretty well established, and there are obvious reasons for that, which the court alluded to. So it's not lengthy argument in my brief because it's so well established that that is the case.
But in your case, weren't there other issues that the claimant brought up that the insurer did that didn't seem quite right? The Hager report and the policy limit issue?
Yes, and we did address that. We addressed it on appeal and below. And what those essentially, I've called them various claims handling activities or litigation activities of defense counsel. And we address each of them in turn in our brief to show that none of them were violations, none of them were unfair or deceptive practices.
And you think all the facts are undisputed as to those?
Yes, we do. The facts that enable you to say that, I mean, one of the activities is offering to mediate. I don't think we need to argue to any great extent that an insurer's offer to mediate a case is somehow an unfair settlement
How about
practice.
misrepresenting the amount of the policy coverage?
That would be if indeed under certain circumstances. In this case, the
Yeah,
record
but
was
you're saying
very
you-
thorough and very clear that it was A, inadvertent, and B.
Is that true? I mean, is that undisputed that it was inadvertent?
Well, it's not undisputed, but we have the entire claims file, and we have affidavits,
But you're
and
asking
nothing was
you're
put
asking the
in.
judge then to make findings of fact on a summary judgment?
There was no 56F here. We have affidavits from every single person who was involved. We have the entire claims file. We have the communications with defense counsel. So I would say, yes, that was ripe for decision. But there's another reason that could not support a finding or going back at this point, because the court basically, in essence, determined that it didn't need to talk about all these separate activities. Rather, it found that the harm, the injury about which the plaintiff was complaining was the fact that the case was not settled, he didn't get the reasonable settlement offer he wanted, and he was forced to litigate. That's the injury he identified. He's identified no other. That's what the court said, and the court went on to conclude that the reason the case, there was no further negotiation, was the decision of not the insurer. Nothing about the insurer's conduct caused that injury. Rather, it was the views and the conduct of the insured himself. And it is because of that, there is no potential causal connection between any of these activities. The one that you refer to, Justice, specifically about the insurance coverage, in fact, it was clear that it made no difference because that was detected when the plaintiffs produced a document that showed that a different coverage year applied. As soon as the carrier saw that, they made the correction. They reported it to everybody within, I think, 24 hours, the record shows, and nobody changed their position on settlement. The plaintiffs remained sky high over $1 million. The defendant said, no, I don't want to settle. Offered only 100, never approved more. It made no difference what that coverage was. So we have a lack of causal connection specifically for that alleged violation, but we also have the broader question about whether there is no causal connection to any injury that this plaintiff has sustained. And you still do need an injury before you have a 93A violation. It's not enough to have, oh, you did something wrong. That's in violation. You still need to prove harm in order to recover under 93A. You may have violated 176D, but if it is of no moment, if it caused no injury or harm, there is no liability.
Could we deal with the elephant in the room? So the consent to settle, your brother argues that 176D creates an obligation. He refers to this footnote 5 in Clegg. Justice Lanks raised the issue of these sort of expedient settlement. Could you inform us here? Because this is complicated. So go ahead.
So, and I welcome the Clegg decision. In fact, it illustrates a point I want to make about how one interprets 176D and particularly subparagraph F, that it isn't as unlimited bar as he suggests. But basically, insurance policy, ordinary liability policies, what we think of, what we're familiar with, auto policies, homeowners policies, that sort of thing, even general liability policies for businesses, have what's called a deems expedient clause, which gives the insurer the complete control over the defense and settlement of any decision without any input from the insured. This obviously creates a tension when you are dealing with insureds who have interests that are beyond purely financial. The ordinary homeowner is very happy if the carrier can settle the claim within the policy limits and get that off his back. True for most litigants.
Is that true? Because doesn't that cause their policy amounts to go up when if they settle? Doesn't that
Yes, that's right.
raise
Yeah.
your?
Well, it could or it couldn't. I mean, you're getting into underwriting standards, but I would, from the little bit I know of underwriting, it's not going to happen on account of one claim for the average homeowner. Auto obviously is regulated in Massachusetts, and if you're in certain accidents or get tickets, that can affect your premium, not just settlement of claims. So essentially, there are a small group of insureds who have unique interests which are not addressed by the deems expedient clause. And it is they who have, in essence, asked for and are willing to pay for, because it costs money, clauses that will protect their right to control settlement. And those are what we've been calling professionals, doctors, lawyers, the kinds of amicus who have weighed in, as well as insurers obviously have weighed in as amicus.
What about the poor
But-
plumbers?
Hmm?
What about the poor plumbers?
The poor plumbers have apparently decided they prefer lower premiums. But let me put it this way, if I can explain what the two interests are that these professionals have.
Better embrace
and I
the
would
plumbers.
suggest- Yeah, they have an interest in their reputation. Many of these things are published. For lawyers, you can get information. For doctors, you certainly can get information. And also they have what's called precedential interests. They want to actively and aggressively defend those areas where things might be gray. It's important to them. And there are also organizations that have those same interests,
But wait.
such as the media.
Well, it's pretty clear why the insured would want that type of clause, but I mean, what happens to the claimant?
So the same thing that would happen when the person doesn't buy insurance. The same thing that happened in the Morrison versus Toys R Us case, when the business ran its own in-house insurance. There is no public policy in favor of controlling litigants' conducts toward each other in terms of whether they choose to have their case heard by a jury.
Except
That's
for
what
you've
happened
got
here.
176D, though.
Yeah, 176D controls the conduct of carriers. It does not control the conduct of insureds.
But the carrier is, their conduct is entering into this type of contract to begin with.
Their conduct, yes, their conduct is offering an option to insureds who might not otherwise purchase coverage. And that is the point that the various amicus have made in this case, that
And why do
these
we
are
care about that?
important.
The lawyers aren't going to purchase liability?
They do not have to purchase liability insurance in Massachusetts. However,
Well, yeah,
on
that's a
the-
big however.
the however is on your, on the BBO site, it will be revealed whether or not they have insurance. That in itself is an issue because since most lawyer insurance is claims made, it's a little, there's no guarantee they will continue to have that insurance at the time a claim is ultimately made down the road. But basically, Massachusetts has decided not to make it mandatory. And some states do and some states don't for lawyers. But basically,
So there's no, the duty, I'm still interested in Justice Budd's question, though. Is there any duty to the insured? And your brother references a statutory amendment that somehow imposes some kind of, could you address that duty if it
okay.
exists?
so 176D originally was designed to, and only did, really, the source was wanting to protect insureds rather than claimants. And that was what was originally enacted, and it was in 1979, not 1973, that it was certain provisions, that it was amended to extend rights to others injured by the forbidden conduct.
Which provision is that in 1979? What's added in 1979?
It became clear that third parties, claimants who weren't parties to the contract, who were injured by violations of certain sub-provisions. I mean, some of the sub-provisions of 176D by their terms only apply to insureds. It says compelling an insured to do something, this court has said. When it says that, obviously, it only goes so far as to protect the insured. To answer a question raised by the Chief Justice in
Well, but
1979.
before you do that, so in 1979, they do what? And what
They
kind of?
amended to allow a third party who is injured, that is not a party to the insurance contract, here, the claimant, for example, to allege a violation of their rights that, so long as it caused them injury. They still need to have an injury. They can't just say, oh, well, this is a bad thing.
Why does this, so why is that provision not relevant to, how does that intersect with consent to settle?
Okay. Okay. Just to finish the history.
Okay, sorry.
No, I apologize. The Chief Justice raised the question of whether the legislature knew there were these consent clauses, or were there these consent clauses when that change occurred. And I think actually on the record, I think we can establish that because the Van Dyke case involved a policy, it was a 1983 case, involved a medical malpractice policy that had a consent clause. And the court alludes to the 1979 amendment, but notes it isn't applicable because the policy predated that amendment. So obviously, we know there was at least one policy in the Commonwealth that was being written to cover doctors that had consent clauses. I think if you read the amicus briefs, they indicate these have been around for many, many decades, and they are all over the country. And they haven't been, by the way, there is no court that has ever held them anywhere to be against public policy.
Has it ever been asked?
Has anyone asked? No. So there have been the three cases that my colleague cited in other jurisdictions where the courts didn't enforce them, but they didn't not enforce them because they were invalid. They basically said they weren't complied with. They didn't give fully informed consent in those circumstances. In all of them also, the challenger was the insured, saying you didn't tell me enough. Which is obviously a very different situation.
The appellants have raised the concern that if you can contract out of 39F, then can the insurer contract out of other statutory obligations as well?
Well, I guess I would say I don't think they've contracted out of 39F, so I reject that premise. What they've done is they've left the thing that has always been in the control of a litigant in the hands of the litigant. And I want to get to this issue of what 176D subsection F actually says and why it is not mandatory, if I may. This court has routinely held that part of liability being reasonably clear is looking at the language of the insurance policy. It's not reasonably clear as to the carrier if there's an exclusion. In Clegg, this court held that an excess carrier, clearly an insurer, was not obligated to extend any offer, even where it was clear that their policy was going to be implicated. They are above a primary, but the damages were way in excess. No obligation, no 176D violation, unless and until the primary extends their limits. And that was based on the language of the contract.
Isn't that a chicken and egg type thing? Because you can't say liability's not clear because he won't or she won't authorize a settlement, right?
Yeah, right. And I don't mean
'Cause
to,
you-
I don't
you
mean
need
to
to go to the-
suggest that.
Right.
Clearly, liability as to the defendant was reasonably clear. There's no issue there. What I'm saying is that in the Clegg case, this court was confronted with an exactly analogous situation. It was a carrier. By its contract, it basically avoided the obligations that my brother suggests are absolute to effectuate settlement. And this court said that was permissible. And one of the reasons it was permissible was because they thought excess policies are good. They don't cost very much. The reason they don't cost very much is because the exposure is less, even though ultimately in a handful of cases it's going to be implicated. And the court felt, rather than write them out of existence, which is exactly what not honoring the language of the contract that says we only come in after the primary would have done, they said they did not violate 176D by essentially sitting on their hands until the primary acted. Same thing in the situation with the self-insured retention,
But there's
which has also been approved by our appeals
But
court.
isn't in Quag, and again, the primary has its own duty to the claimant.
Correct.
right? So you're not in, here we've got the fact that if the insured cannot do anything, that claimant's left with nothing but the lawsuit. I'm trying to get back to what that 176, that 1979 amendment, does it put any limitations on consent to settle provisions?
Well, it doesn't by its terms, and this court has not interpreted to do so in a whole variety of other situations where the insurance policies have essentially allowed it not to be required to make that offer. A large self-insured retention, for example, that's the litigant's responsibility. But there is a Massachusetts case, an appeals court case, that says that's fine. That doesn't violate 176D, leaving the basic settlement decision, in essence, to the insured. He has to offer.
Your brother is presenting an all-or-nothing proposition to us, and it seems like so are you. So that the claimant has, if the insured, I'm trying to understand, you say if the insured is completely unreasonable, there's nothing the insurance company has to do, right? In your view?
Well, no, there's an informed consent requirement. In this case, we know what they did. They informed him, they cajoled him, they warned him. But yes, at some level, that is the basis of this notion. It is rare. That is one reason we haven't seen these cases, Justice Lank, is because it doesn't happen very often. Usually a well-informed insured is going to decide it is in their interest not to face this significant exposure.
Can I, on that point, can I ask you, do you agree with the amicus suggestion? I forget which one of the amicus it was. One of them offered this notion that we should.
The engineer's brief, I think,
okay.
yeah.
Informed consent really sort of striking a balance of some sort, at least as between insurer and insured, as to what the obligations were.
Yeah. It means that the insurer still bears responsibility for making sure that everything is done that is possible to convince a recalcitrant insured. And as I said, that typically works. The fact that in the rare case it doesn't work, and it's extremely rare because we haven't seen these cases,
Is that because
doesn't mean you write them out of the availability to the whole market as a whole.
I was puzzling over this morning about what the economics were of these kinds of consent to settle policies.
Carriers don't like them. They take away their control, so they price them higher. They expose them to greater risks, and they'd rather be in control of the process of deciding whether or not it's better to settle cheaply early on, even if a case is frivolous or not. That was one of the reasons the legislature initially enacted 176D, was to prevent overreach by carriers whose economic interest is in conflict with that of their insured, often. Carrier would be perfectly happy to settle a frivolous claim if they could do it cheap enough.
So you're saying in some ways this conflict is almost inherent in these consent to settle cases?
Absolutely.
Because the insurer really wants to settle a case while the insured may not, even
Correct.
irrationally may not.
And in other cases, I would say the opposite. That was the other concern of the legislature originally in 176D, where the insureds actually bore some excess liability. They were concerned that carriers were not being careful enough with the insured's money as distinct from their own. And that was part of the original impetus to put in subsection F, which did not apply clearly to claimants, but rather only protected insureds who could say, hey, liability is clear, you should be settling this case, I'm going to be exposed if you don't.
Yeah.
So it is part of a three-part process. The language is not absolute enough to answer
Could you
every
address
situation.
the expedient why it's not appropriate? I don't know if we've imposed these expedient settlement provisions elsewhere, but why is that not a solution here?
Well, it's a solution, but it's not a solution that is of benefit to take completely out of the loop insureds. I mean, part of the problem is, what is an insured then going to say? I mean, how is an insured going to say you didn't appropriately view my economic interest, all you did was honor your own? That was the original evil that 176D was designed to prevent, to make sure the carrier acted in a way that it did not put its own economic interests ahead of that of the insureds
But
with
that
whom it
exists, right?
contracted.
I mean, that 176D exists to solve that problem, right? So why wouldn't we want to do the expedient?
Well, it doesn't necessarily solve the problem, and it certainly doesn't address the problem that all of these professionals and organizations like the Boston Herald, who want to protect a certain area of freedom of action around the First Amendment, and therefore want to contest cases, even if,
Oh, I know.
you know,
that, I
they are
know
not likely to prevail.
Is the hammer clause the answer then?
that. Represent
So the hammer clause actually is not an answer that I think, I mean, it'd be an answer for insurers, because all it does is put the control back in the hands of the insurer. It doesn't help the insured at all. A hammer clause would enable a carrier to say, I can settle this case for $100,000. You have a $500,000 policy. If you don't agree, your policy limits go down to 100. And if I spend anything defending the case, they're going to go down further. At the end of the day, when the plaintiff recovers their 100 or 150, there's only $50,000 left on that policy. Now they have to go chase the insured. So it doesn't really help claimants, except when it can convince, you know, the recalcitrant insured to an extent that
What about if
informed
we added a
consent would not.
provision on we say consent to settle clauses are fine so long as such consent is not reasonably withheld?
Okay. So there are two issues about that.
Because we often interpret.
Yeah, it makes every single settlement subject to suit by someone, either the plaintiff
I'm
or
not
the
saying it's a good
insured. It is-
idea, I'm just asking.
Yeah, and number two, and I agree with what the panel's sense was, is that it should not be in the process of trying to come up with the exact correct language and say it is the only correct and permissible language. That is a job for the legislature to do.
Well, but the legislature hasn't dictated these provisions. The question is, are these consent to settle provisions consistent with 176D? Particularly, you say these are rare. Most insureds behave like normal people. So how do we deal with the irrational insured? We're not saying the Herald's the irrational insured.
That is part of the problem.
but-
Anytime you're deciding,
You are.
So how do we deal with when we do have an irrational insured who doesn't want to settle even though,
it may be the price of providing insurance that otherwise does not, you know, to the maximum number of people who want to purchase it, because on the whole, the public is better off if people buy insurance policies rather than not. And it's part of the public policy that people can act irrationally and can bring lawsuits and can defend themselves, even if at the end of the day, they lose, you know, which is what happened here. Neither party got the money they wanted. Jury picked a number somewhere in between, actually closer to this irrational insured's view, and he fully paid the judgment.
The 3 subsection 9 focuses on conduct of the insurer. What's unusual about this is that the plaintiff here is saying that the conduct of the insurer effectively, which was unfair, was the inclusion of this provision. Is there anything in the statute which says an insurer may not include in a contract anything?
I am not capable of answering that question without looking at all the different
Go back.
subdivisions of
Okay,
the
so, I mean, this
statute. I
would be-
apologize.
so-
I'm not aware of anything.
Would be the first time in which we would be saying what the legislature intended to do was to say that thou shalt not include a provision in your insurance contract which
Right.
does something.
Right, other than in other statutes, like the sort of mandatory terms in the auto policy, those are mandated. The fire policy is mandated, and that's first party, by legislation. Auto policy is governed by the Division of Insurance, has certain
Clear
required
statutory
terms.
language.
Yes. But that's for specific policies. And it might be the Division of Insurance that has that kind of say, but they certainly have not ever ruled that these things are inappropriate.
So they've done it only when they have decided to regulate more precisely the terms of an insurance policy.
Correct.
All right, thank you.
Thank you.
And we'll take our morning break.